Well, well, what do we have here? Another one who thinks the rules don't apply to them. Let me guess, you were just minding your own business when that speed camera caught you going 15 over, right? They always have an excuse. The voice dripped with condescension, each word carefully crafted to humiliate. Judge Thornfield Garrett peered down from his elevated bench like a predator surveying wounded prey. His silver hair caught the harsh fluorescent light, casting shadows that made his pale blue eyes appear almost colorless. The black robe that should have symbolized impartial justice instead seemed to amplify his arrogance. Standing before him in the defendant's section was Celeste Vaughan, a woman whose calm composure stood in stark contrast to the theatrical aggression aimed at her. She wore a simple navy blazer over dark slacks, her hair pulled back in a modest bun. Nothing about her appearance suggested power or privilege. To the packed gallery behind her, she looked like any other working professional caught in the grinding machinery of traffic court. But appearances can be devastatingly deceptive. The traffic citation clutched in her hand bore a timestamp that would prove impossible. 4:37 p.m. on a Tuesday afternoon, Oakwood Boulevard and 5th Street intersection. The location was 200 miles from where she had actually been, presiding over an emergency judicial conference with 11 other state Supreme Court justices. The meeting had been recorded, photographed, and documented by court stenographers. She had the receipts. "Your Honor," she began, her voice steady and measured, "I believe there has been a significant error in this citation. I was not at the location specified on the date and time in question." Judge Garrett's laugh was sharp and ugly. It echoed through the cramped courtroom, bouncing off wood-paneled walls that had witnessed decades of similar small cruelties. Several court officers joined in the mockery, their chuckles creating a chorus of institutional disdain. "Error? Oh, that's rich. They all claim errors, don't they, Officer Meridian?" Blake Meridian, a heavy-set bailiff with dead eyes and a perpetual sneer, nodded enthusiastically from his position by the door. His hand rested casually on his service weapon, a subtle intimidation tactic he had perfected over years of courthouse bullying. "Every single time, Your Honor. Never met a traffic violator who was actually guilty." The gallery shifted uncomfortably. These were working people, mostly minorities, who had learned through bitter experience that Judge Garrett's courtroom was where justice came to suffocate. They watched the exchange with the resigned horror of people who had witnessed this performance before. Celeste remained perfectly still, her breathing controlled. She made no move to defend herself verbally, instead choosing to observe and document. Her trained legal mind was already cataloging violations. Due process, equal protection, basic judicial conduct. Each slight would be remembered, each procedural breach carefully noted. But what Judge Garrett didn't know, what none of them knew, was that he had just made the biggest mistake of his career. The lock clicks twice, then silence. The Millbrook County Courthouse squatted like a concrete tumor in the heart of what had once been a thriving downtown district. Built in 1973, its brutalist architecture seemed specifically designed to crush the human spirit. No natural light penetrated its interior corridors. The air conditioning system wheezed and rattled, creating a constant low-frequency hum that made productive thought nearly impossible. Celeste had arrived 45 minutes early, parking her modest sedan 3 blocks away to avoid the courthouse's overpriced parking garage. She needed to see this place through the eyes of an ordinary citizen, not through the privileged lens of judicial authority. The walk gave her time to observe, to absorb the atmosphere of dread that seemed to emanate from the building itself. The courthouse entrance funneled visitors through a security checkpoint staffed by officers who appeared to view every entrant as a potential threat. She watched as an elderly Latino man was subjected to an unnecessarily thorough search, his dignity stripped away one humiliating pat-down at a time. When he asked a question about which courtroom he needed, the guard's response was pure venom. "Can't you read English? The board's right there. Now move along before you hold up the line." The old man flinched as if he had been physically struck. His shoulders curled inward as he shuffled away, diminished by an interaction that should have been routine courtesy. This wasn't security. It was ritualized degradation, a system designed to remind certain people of their place in the hierarchy. Celeste filed the incident away mentally. First violation noted. The lobby buzzed with the nervous energy of people who had been summoned against their will. Traffic court was scheduled for 10 a.m. sharp, and the benches were already filling with defendants clutching crumpled citations and worried expressions. She took a seat near the back, close enough to observe but far enough away to avoid drawing attention. The conversations around her painted a grim picture of systematic bias. A young African-American woman in scrubs, clearly a healthcare worker between shifts, whispered urgently into her phone. "I can't afford to lose my license, Marcus. I need this job. But my cousin said Judge Garrett gave her 6 months suspension for an expired registration. 6 months for paperwork being 2 days late. 3 seats over, a middle-aged white man in an expensive suit spoke casually with his attorney. Don't worry about Garrett. He's tough but fair. I had him last year for that DUI thing. Got it knocked down to reckless driving. Probably just community service this time. The disparity was stark and unmistakable. 2 cases, similar circumstances, dramatically different expectations based solely on the color of the defendant's skin. Celeste had seen the statistical analysis, had reviewed the data that painted Millbrook County as one of the most racially biased judicial districts in the state. But statistics were abstract. This was human suffering made tangible. Her attention was drawn to the court staff beginning their morning routine. Court clerk Daphne Sterling, a sharp-featured woman with carefully styled blonde hair, moved through her duties with bureaucratic precision. But Celeste noticed something troubling in her interactions. When processing paperwork for white defendants, Sterling was thorough and helpful, explaining procedures and offering guidance. For defendants of color, her demeanor shifted to barely concealed hostility, her explanations curt and deliberately unclear. Next, citation number, full name, and make sure you speak clearly, Sterling snapped at a young black man approaching her window. When he asked for clarification about a fee payment, her response was ice cold. It's all explained on the form. If you can't understand basic instructions, that's your problem, not mine. Second violation documented. Prosecutor Wells Ashford made his entrance like a man auditioning for a television courtroom drama. Tall, impeccably groomed, with the kind of aggressive confidence that comes from rarely facing meaningful opposition. He surveyed the packed gallery with obvious satisfaction. These weren't cases to him. They were statistics, conviction numbers that would look impressive on his resume when he inevitably ran for higher office. Celeste watched him interact with the court staff, noting the easy familiarity that suggested years of collaboration. This wasn't a justice system. It was a machine, carefully calibrated to produce predetermined outcomes. The defendants were simply raw material to be processed. What happens when absolute power meets absolute justice? You're about to witness a courtroom showdown that will leave you speechless. But first, make sure you're subscribed because this story gets more shocking by the minute. And you won't want to miss a single twist. The courtroom itself was a monument to intimidation. High ceilings designed to make petitioners feel small. Dark wood paneling that absorbed light and hope in equal measure. The judge's bench towered above everything else, a throne from which verdicts rained down like divine judgment. As 10 a.m. approached, the defendants were herded into the courtroom like cattle awaiting slaughter. The bailiffs, led by Camden Pierce, a stocky man with the dead-eyed stare of someone who had spent too many years confusing authority with brutality, positioned themselves strategically around the room. Their message was clear. Resistance would be met with force. The gallery filled with family members, friends, and the simply curious. But even the observers seemed subdued, speaking in whispers as if afraid their voices might attract unwanted attention. This was Judge Garrett's kingdom, and everyone present understood the rules of his realm. Celeste took careful note of everything: the positioning of court personnel, the procedures being followed, the atmosphere of barely suppressed hostility that permeated the room. Her legal mind automatically cataloged potential violations, building a case that would soon prove devastatingly effective. The morning docket was called, and the parade of misery began. Case after case revealed the same pattern: harsh sentences for defendants of color, lenient treatment for white defendants with identical charges. A young Latina woman received a $600 fine and license suspensions for a registration violation of saying. 20 minutes later, a white college student with the same infraction walked away with a warning and community service. Each ruling added another piece to the mosaic of institutional racism that defined Judge Garrett's courtroom. But for now, Celeste remained silent, patient, gathering evidence with the methodical precision of someone who understood that justice delayed was not necessarily justice denied. Sometimes it was justice perfected. Speaking of legal protection, have you ever worried about your rights being violated? Legal Shield offers 24/7 access to experienced attorneys for less than $30 per month. Whether it's traffic violations, workplace issues, or any legal concern, you'll have professional representation ready. Don't wait until you're facing a biased system alone. Visit LegalShield.com/justice and get your first consultation free, because everyone deserves equal protection under the law. The morning wore on, each case reinforcing the pattern of bias that characterized Judge Garrett's interpretation of justice. By the time her name was called, Celeste had witnessed enough constitutional violations to justify a federal investigation. What she hadn't anticipated was becoming the catalyst for exactly that kind of scrutiny. But as she rose from the gallery and walked toward the defendant's table, she carried with her not just the weight of her own case, but the accumulated grievances of every person who had been diminished, humiliated, and denied equal treatment in this room. The reckoning was about to begin. Celeste Vaughn versus State of Virginia. The clerk's voice carried no emotion, just the bureaucratic monotone of someone who had called thousands of names to face thousands of verdicts. But as Celeste approached the defendant's table, something shifted in the courtroom's atmosphere. Perhaps it was her stride, confident without being defiant, measured without showing fear. Perhaps it was the way she carried herself, spine straight, shoulders squared, projecting an authority that seemed at odds with her modest appearance. Judge Garrett studied her with the calculating gaze of a predator sizing up potentially dangerous prey. His experience had taught him to identify troublemakers quickly, and something about this woman triggered his internal alarm systems. She didn't display the usual nervousness of traffic court defendants. She wasn't fidgeting, wasn't avoiding eye contact, wasn't displaying any of the submissive behaviors he had come to expect from people in her position. "Miss Vaughn," he began, his voice carrying the particular brand of condescension he reserved for defendants who needed to be put in their place quickly. "You stand accused of exceeding the posted speed limit by 15 miles per hour on Oakwood Boulevard. A pretty clear-cut case of disregarding traffic safety laws. How do you plead?" Celeste remained standing, her hands clasped loosely behind her back in a posture that suggested both respect and readiness. When she spoke, her voice carried an undertone of authority that made several court officers exchange uncomfortable glances. "Your Honor, before entering any plea, I must respectfully request that the court review the procedural requirements for traffic camera citations under Virginia Code Section 46.2-882. The courtroom fell silent. Traffic court defendants didn't typically cite specific statutes. They pleaded guilty, paid their fines, and disappeared back into anonymity. Judge Garrett's eyes narrowed dangerously. "Excuse me? Are you questioning this court's understanding of Virginia traffic law?" "Not at all, Your Honor. I'm simply requesting that proper procedure be followed. Specifically, the requirement that camera calibration records be made available for review prior to accepting any citation as valid evidence." The words hung in the air like a challenge. Prosecutor Ashford shifted uncomfortably at his table, suddenly aware that his easy morning of rubber-stamped convictions was about to become significantly more complicated. This wasn't the usual traffic court theater. This was someone who actually understood the law. Judge Garrett's face darkened. He had spent 30 years on the bench, and he wasn't about to be lectured by some random defendant who had obviously been coached by a cut-rate attorney. "Miss Vaughn, this is traffic court, not the Supreme Court. We don't need to complicate simple proceedings with unnecessary legal gymnastics. The camera recorded your vehicle exceeding the speed limit. End of discussion." But Celeste wasn't finished. She reached into her modest handbag and withdrew a manila envelope, moving with deliberate precision that suggested absolute confidence in her next move. "Your Honor, I have documentation proving that I was physically present at a location 200 miles from the cited intersection at the time this alleged violation occurred." She opened the envelope and withdrew a set of photographs clearly time-stamped with the same date and time as her traffic citation. The images showed her seated at a conference table surrounded by other professional individuals, clearly engaged in some kind of official meeting. These photographs were taken during a judicial conference that lasted from 2 p.m. until 6 p.m. on the day in question. I was never within 50 miles of Oakwood Boulevard. The silence that followed was pregnant with possibility. Even Judge Garrett seemed momentarily taken aback by the specificity and apparent authenticity of her evidence. But his recovery was swift and predictably vicious. "Anyone can fake photographs these days. Digital manipulation is child's play. I suppose next you'll tell me you were performing brain surgery or running a Fortune 500 company during this alleged meeting." His sarcasm drew nervous laughter from the court staff, but Celeste remained unmoved. If anything, her composure seemed to deepen, as if his mockery was exactly what she had expected. "The photographs are merely supporting documentation, Your Honor. The primary evidence of my whereabouts exists in official court records that can be independently verified." "Court records?" Judge Garrett's voice rose dangerously. "What court records? What are you talking about?" For the first time since entering the courtroom, Celeste allowed the ghost of a smile to cross her features. It wasn't triumphant or mocking. It was the patient expression of someone who had been several moves ahead throughout the entire conversation. "The records of the Virginia State Judicial Conference, Your Honor. I was attending in an official capacity." The courtroom atmosphere shifted perceptibly. Several gallery members leaned forward, sensing that they were witnessing something unprecedented, Prosecutor Ashford's face had gone pale as he began to recognize the implications of what he was hearing. Official capacity? Judge Garrett's voice cracked slightly, but he recovered quickly, doubling down on his authoritarian approach. Ms. Vaughn, I don't know what game you think you're playing, but this court will not be manipulated by elaborate stories and manufactured evidence. You will enter a plea, or I will hold you in contempt. I understand the court's position, Celeste replied evenly. However, I must insist that due process be followed. Specifically, I invoke my right under the 14th Amendment to equal protection under the law, which requires that evidence be properly authenticated before being admitted. The constitutional reference hit the courtroom like a thunderclap. This was no longer simple traffic court. This had become a federal constitutional issue. Judge Garrett's face flushed red as he realized he was losing control of his carefully orchestrated proceedings. Federal constitutional rights? In my courtroom? Ms. Vaughn, you're trying my patience. This is a simple traffic violation, not a civil rights case. But Celeste was just getting started. She withdrew a small digital recording device from her jacket pocket and placed it on the defendant's table, making sure it was clearly visible to everyone in the courtroom. Your Honor, I'm invoking my right under Virginia Code Section 18.2-464 to record these proceedings for the protection of all parties involved. Judge Garrett exploded. You will not record anything in my courtroom. Bailiff, confiscate that device immediately. But Celeste remained calm, her voice taking on an edge of steel that made several court officers unconsciously step backward. With respect, Your Honor, the statute clearly states that any party to a legal proceeding has the right to create an audio record for their protection. Attempting to prevent such recording would constitute a violation of Virginia state law and potentially federal civil rights statutes. The standoff was now complete. Judge Garrett glared down from his bench, his authority directly challenged by a defendant who clearly knew far more law than any traffic violator had a right to know. The court staff watched nervously, unsure how to proceed. The gallery held its collective breath, sensing that they were witnessing history in the making. What none of them realized was that Celeste Vaughn had been recording everything from the moment she entered the courthouse. The digital device on the table was merely a psychological pressure point. The real documentation was already complete, captured by equipment so sophisticated that it would stand up to any legal challenge. Court cases can be financially devastating, even when you win. That's where litigation insurance from ARAG comes in. For pennies on the dollar, you can protect yourself from legal costs that could reach tens of thousands. ARAG covers attorney fees, court costs, and expert witness fees in over 100 legal situations. Visit ARAG.com protection and get a free quote. Don't let legal bills bankrupt you while fighting for justice. The tension in the courtroom had reached a breaking point. Judge Garrett's face had shifted from red to purple, the veins in his neck standing out like rope under his judicial robes. He was a man accustomed to absolute authority, suddenly finding his power questioned by someone who clearly understood the law better than most attorneys who appeared before him. Ms. Vaughn, he said, his voice dropping to a dangerous whisper that somehow carried more menace than his earlier shouting. You seem to have confused this proceeding with some kind of constitutional law seminar. Let me remind you where you are. This is my courtroom. I am the judge. You are the defendant. Those are the only roles that matter here. He leaned forward, his pale eyes glittering with malice. Now you can plead guilty, pay your fine, and walk out of here with a simple traffic violation on your record. Or you can continue this ridiculous performance and find yourself facing contempt of court charges, potential jail time, and legal fees that will make your original citation look like pocket change. The threat hung in the air like a toxic cloud. This was Judge Garrett's standard operating procedure. Escalate the stakes until defendants submitted to his authority rather than risk destruction. It had worked thousands of times before. It was about to fail spectacularly. Celeste looked up at him with eyes that held no fear, no submission, no recognition of his presumed authority. Instead, she projected the quiet confidence of someone who knew exactly how this confrontation would end. Your Honor, she said quietly, there is a third option. The words landed like a physical blow. Judge Garrett's carefully constructed facade of judicial authority wavered for just a moment, replaced by something raw and dangerous. His courtroom had become a stage for public humiliation, and he was no longer directing the performance. A third option? His voice cracked like a whip. Ms. Vaughn, I'm beginning to think you have serious difficulty understanding basic instructions. There are only two choices here, compliance or consequences. But even as he spoke, something had shifted in the courtroom's power dynamic. The gallery sensed it first, a subtle change in the air, like the electrical charge before a thunderstorm. Court reporter Janet Holloway found herself paying closer attention to her transcription, instinctively understanding that this proceeding might require exceptional accuracy. Prosecutor Ashford cleared his throat nervously, half rising from his chair. "Your Honor, perhaps we could take a brief recess to review the defendant's documentation." "Sit down, counselor." Judge Garrett's command was sharp enough to cut glass. "This defendant will learn to respect this court's authority, or she will face the consequences of her defiance." Celeste remained perfectly still, but her presence had begun to fill the room in a way that was impossible to ignore. Several gallery members had quietly activated their cell phone cameras, sensing that they were witnessing something extraordinary. The court staff exchanged increasingly nervous glances, their usual swagger replaced by uncertainty. "Your Honor," Celeste said, her voice carrying a new undertone that made Bailiff Pierce unconsciously straighten to attention. "I believe you may want to review the documentation I've provided before proceeding further." She gestured to the photograph still lying on the defendant's table. Images that clearly showed her in what appeared to be an official government meeting at the exact time she was allegedly speeding through downtown Millbrook. Judge Garrett barely glanced at the evidence. "Miss Vaughan, I've seen every trick in the book. Photoshopped pictures, fabricated alibis, manufactured witnesses. You're not the first defendant to try to bamboozle this court with elaborate fiction." His dismissal was casual, contemptuous, but Celeste's response carried a precision that made Court Clerk Sterling look up from her paperwork with sudden alarm. These photographs were taken during an emergency session of the Virginia State Judicial Conference, specifically addressing updates to federal sentencing guidelines under United States Code Title 18, Section 3553-A. The meeting was attended by 12 sitting judges and recorded by official court stenographers. The specificity of her legal citation sent a ripple of unease through the courtroom. This wasn't the language of a random traffic violator. This was someone with intimate knowledge of federal judicial procedure. Prosecutor Ashford felt sweat beginning to form on his forehead. Something was very wrong with this situation, but Judge Garrett seemed determined to bulldoze forward regardless of the mounting evidence that they were dealing with something far beyond a simple traffic case. Federal sentencing guidelines? Judge Garrett's laugh was harsh and mocking. "Miss Vaughn, your imagination is impressive, but your legal knowledge is clearly limited to whatever you managed to Google in the courthouse hallway. Federal guidelines don't apply to state traffic violations." "Actually, Your Honor, they do when the violation involves constitutional due process issues and potential civil rights violations under 42 U.S.C. Section 1983. The citation landed like a bomb in the courtroom. 42 U.S.C. Section 1983 was the federal civil rights statute that allowed citizens to sue government officials for constitutional violations. It was the legal nuclear weapon that every judge feared most, because it could destroy careers and bankrupt entire judicial districts. Judge Garrett's face went ashen. "Are you threatening this court?" "Not at all, Your Honor. I'm simply noting that procedural violations in traffic cases can escalate to federal civil rights issues when they demonstrate a pattern of discriminatory enforcement." The room fell silent except for the nervous scratching of the court reporter's pen. Even she understood that this conversation had crossed into dangerous territory. Bailiff Pierce moved closer to the defendant's table, his hand resting on his service weapon in a gesture that was both unconscious and deeply revealing. "Miss Vaughn," Judge Garrett said, his voice dropping to a whisper that somehow carried more menace than any shout. "You seem to have mistaken this courtroom for some kind of law school classroom. Let me remind you of something very important." He paused dramatically, surveying his kingdom. The court officers who jumped at his commands. The prosecutor who rarely challenged his decisions. The gallery full of citizens who had learned to accept whatever judgment he chose to dispense. I have been on this bench for 30 years. 30 years of maintaining order, upholding the law, and dealing with defendants who think they're smarter than the system. In all that time, I have never allowed anyone to turn my courtroom into a circus. His voice began to rise, building to the kind of theatrical crescendo that had intimidated thousands of defendants into submission. You want to quote federal statutes? You want to challenge established procedure? You want to question this court's authority? Fine. Here's what's going to happen. The injustice you're witnessing is heartbreaking, but it's about to take a turn that will restore your faith in the system. If stories of courage against corruption move you, hit that like button and share this with someone who needs to see that justice can prevail. Judge Garrett stood, his black robes billowing around him like the wings of some predatory bird. I am finding you in contempt of court for disrupting these proceedings and showing disrespect to judicial authority. Bailiff Pierce, prepare to take Miss Vaughn into custody. The order sent shockwaves through the gallery. Several people gasped audibly, and at least one person called out in protest before quickly falling silent under the baleful glare of the court officers. This was the moment Judge Garrett lived for, the demonstration of absolute power over people who dared to challenge his authority. But Celeste didn't move. She didn't flinch, didn't step backward, didn't show any sign of the fear that Judge Garrett expected to see. Instead, she looked up at him with an expression that was almost pitying. "Your Honor," she said quietly, "I strongly advise you to reconsider that order." The words carried a weight that seemed to settle over the entire courtroom like a heavy blanket. Judge Garrett stared down at her, his brain struggling to process the complete absence of submission in her voice. "Advise me?" His voice cracked with incredulous rage. "You advise me? Who do you think you are?" Celeste reached into her jacket pocket and withdrew a leather credential case. The movement was smooth, deliberate, practiced. Bailiff Pierce tensed, his hand moving to his weapon, but something in her demeanor made him hesitate. "Your Honor," she said, her voice now carrying unmistakable authority, "I am exactly who I need to be." She opened the credential case with a sharp snap that echoed through the silent courtroom. The gold badge inside caught the harsh fluorescent light and threw it back like a beam of justice made tangible. The silence that followed was so complete that the courthouse's ancient ventilation system sounded like thunder. Judge Garrett stared at the badge, his brain refusing to process what his eyes were clearly seeing. Court Clerk Sterling's pen fell from nerveless fingers and clattered to the floor. Prosecutor Ashford's mouth hung open in an expression of pure horror. Bailiff Pierce took an involuntary step backward, his hand falling away from his weapon as if it had suddenly become red hot. Even the gallery seemed to lean forward collectively, sensing that they were witnessing something that would be talked about for decades to come. Celeste Vaughn looked up at Judge Thornfield Garrett with eyes that no longer held any deference, any recognition of his authority, any acknowledgement of his power. Instead, she projected the absolute confidence of someone who had just reminded a very small man of exactly how small he really was. "Your Honor," she said, her voice now carrying the full weight of the office she represented, "my name is Chief Justice Celeste Vaughn. I am the Chief Justice of the Virginia State Supreme Court." The words hit the courtroom like a physical explosion. Judge Garrett swayed as if he had been struck, his hands gripping the edge of his bench for support. The color drained from his face so quickly that for a moment it seemed he might collapse entirely. The transformation was instantaneous and devastating. The woman he had been mocking, threatening, and preparing to jail was not just any lawyer or legal professional. She was the highest-ranking judge in the entire state judicial system. She was his boss's boss's boss. She was the one person who could end his career with a single phone call. More than that, she was someone who had just witnessed 30 minutes of the most blatant judicial misconduct imaginable. Every threat, every procedural violation, every unconstitutional abuse of power had been documented by someone with the authority and responsibility to act on that information. Judge Garrett opened his mouth to speak, but no words came out. For the first time in 30 years on the bench, he found himself completely speechless. Chief Justice Vaughn closed her credential case with the same deliberate precision she had used to open it. When she spoke again, her voice carried the quiet authority of someone who had never needed to raise her voice to command respect. "Your Honor, what she said, and the title now carried a weight that made it sound almost mocking. "I believe we were discussing proper procedure for traffic citations." The revelation had transformed the courtroom into something resembling a disaster zone in the moments after impact. Judge Garrett remained frozen behind his bench, his brain struggling to process the magnitude of his catastrophic error. The man who had built his reputation on swift, decisive action now found himself paralyzed by the implications of what he had just witnessed. Court Clerk Daphne Sterling had gone completely white, her carefully applied makeup standing out like war paint against her pale skin. Her mind was racing through every interaction she'd had with the Chief Justice during the morning's proceedings. Every dismissive comment, every procedural shortcut, every moment of casual disrespect. Each memory felt like another nail in the coffin of her career. Prosecutor Wells Ashford had slumped in his chair as if someone had cut his puppet strings. His political ambitions, built on a foundation of easy convictions and tough-on-crime rhetoric, had just crumbled into dust. He had not only failed to recognize the Chief Justice of the state Supreme Court, he had actively participated in her systematic humiliation. But it was Bailiff Camden Pierce who understood the true scope of the disaster. His hand was still trembling from its recent proximity to his service weapon. He had been seconds away from laying hands on the most powerful judicial officer in the Commonwealth of Virginia. The thought made him nauseated. Chief Justice Vaughn surveyed the wreckage with the calm assessment of someone who had seen institutional corruption before and knew exactly how to dismantle it piece by piece. She reached into her briefcase and withdrew a compact digital recorder, placing it on the defendant's table with deliberate precision. "For the record," she said, her voice cutting through the stunned silence, "this device has been recording our entire interaction. Additionally, I should inform the court that I am currently wearing Department of Justice monitoring equipment as part of an ongoing federal investigation into judicial bias in Virginia state courts." The second revelation hit like a follow-up earthquake. Not only had they humiliated the Chief Justice, they had done so while being recorded for a federal investigation. Every threat, every procedural violation, every moment of obvious racial bias was now documented evidence in what would inevitably become a massive federal case. Judge Garrett finally found his voice, though it emerged as little more than a croak. "Chief Justice Vaughn, I had no idea. If I had known." "If you had known what, Judge Garrett?" Her voice remained perfectly level, but carried an undertone of steel that made everyone in the courtroom unconsciously straighten. "If you had known my identity, you would have followed proper procedure? You would have treated me with respect? You would have adhered to constitutional requirements?" She paused, allowing the implications of his words to sink in. "Are you suggesting that proper judicial conduct is reserved only for those whose identity and authority you recognize?" The question hung in the air like a sword over his head. Any answer would be an admission of either incompetence or deliberate bias. Judge Garrett's mouth opened and closed soundlessly like a fish gasping for water. Chief Justice Vaughn turned her attention to the rest of the court staff, each of whom seemed to shrink under her gaze. "Bailiff Pierce, during this proceeding you threatened a defendant with physical force for exercising her constitutional rights. Court Clerk Sterling, you deliberately obstructed proper procedure and showed obvious bias in your treatment of different defendants. Prosecutor Ashford, you remained silent while witnessing clear violations of due process and judicial conduct." She paused, consulting a small notepad that she had been writing in throughout the morning's proceedings. "More importantly, my observations this morning suggest that these behaviors are not isolated incidents, but part of a systematic pattern of bias and misconduct that has persisted for years. Want to understand your constitutional rights like Chief Justice Vaughn? The Constitution Institute offers online courses taught by legal experts that break down complex law into understandable terms. Learn about civil rights, criminal procedure, and judicial oversight. Use promo code JUSTICE50 at constitutioninstitute.edu for 50% off your first course. Knowledge of the law is your best defense against those who would abuse it." The morning's earlier cases suddenly took on a sinister new significance. Every harsh sentence imposed on defendants of color, every lenient treatment given to white defendants, every casual cruelty inflicted on the vulnerable, all of it had been witnessed and documented by someone with the power to demand accountability. Chief Justice Vaughn reached into her briefcase again and withdrew a thick manila folder. "I have here copies of sentencing data from this courtroom covering the past 5 years. The statistical analysis reveals patterns of bias so obvious and systematic that they constitute clear violations of the Equal Protection Clause of the 14th Amendment." She opened the folder and withdrew several charts and graphs, spreading them on the defendant's table where everyone could see them. The visual evidence was damning. Bar graphs showing racial disparities in sentencing, pie charts revealing systematic differences in fine amounts, trend lines demonstrating that bias had actually increased over time. African American defendants in this courtroom receive sentences that are, on average, 47% longer than white defendants for identical charges. Fine amounts show similar disparities, with minority defendants paying significantly more for the same violations. Prosecutor Ashford made a weak attempt at damage control. "Chief Justice Vaughn, those statistics could be explained by various factors: criminal history, attitude in court, quality of legal representation." "Mr. Ashford," she replied without looking at him, "I have reviewed the complete case files. The disparities persist even when controlling for all relevant legal factors. What we have here is not explained by legitimate judicial considerations. It is systematic discrimination based solely on race." The words landed like bullets. This wasn't just institutional bias. It was deliberate, sustained, and illegal discrimination that violated both state judicial conduct rules and federal civil rights law. Judge Garrett made one last desperate attempt to salvage the situation. "Chief Justice, surely we can discuss this matter privately. Perhaps there's been some misunderstanding." "Judge Garrett," she interrupted, her voice cutting through his pleading like a blade, "there has been no misunderstanding. I came here today as an ordinary citizen, exactly as thousands of other defendants have appeared before you over the years. The treatment I received, the dismissal of evidence, the procedural violations, the threats of imprisonment for exercising constitutional rights. This is how you conduct your courtroom when you believe no one important is watching. She gestured toward the gallery where dozens of people sat in stunned silence, many of them holding up cell phones to record the historic confrontation. But here's what you failed to understand, Judge Garrett. Every person who appears before you is important. Every defendant deserves the same respect, the same procedural protections, the same presumption of innocence that you would have granted me if you had known my identity. The moral weight of her words settled over the courtroom like a judgment from a higher court. This wasn't just about legal procedure. It was about the fundamental principle of equal justice under law, the bedrock promise that democracy makes to all its citizens. Chief Justice Vaugh Guan began gathering her materials with the methodical precision of someone whose work was nearly complete. This court is hereby suspended pending a comprehensive investigation by the Virginia State Judicial Review Board. Additionally, I am referring this matter to the United States Department of Justice Civil Rights Division for federal review. She paused at the gate separating the defendant's area from the gallery, turning back to address Judge Garrett one final time. 30 years on the bench, Your Honor. 30 years of public trust placed in your hands. The question that will now be answered is whether you used that trust to serve justice or to serve your own prejudices. The silence that followed her exit was profound and complete. Judge Garrett remained slumped in his chair, staring at the empty defendant's table where his career had just come to an end. The court staff sat frozen in place, each lost in contemplation of their uncertain futures. Judge Garrett thinks he has all the power, but he's about to learn he's been playing chess with a grandmaster. What happens next will shock you to your core. Don't even think about clicking away because the reveal is coming and it's absolutely devastating. In the gallery, dozens of people who had been victims of the court's bias began to realize that justice, real justice, might finally be within reach. For the first time in years, hope had entered the Millbrook County Courthouse, but this was only the beginning. The wheels of justice had been set in motion, and they would not stop turning until every corner of the corrupt system had been exposed to the harsh light of accountability. Chief Justice Celeste Vaugh walked out of the courthouse she had entered as an anonymous defendant, leaving behind a trail of destruction that would reshape the entire Virginia judicial system. The reckoning had begun, and it would be thorough, merciless, and absolutely just. The lock had clicked twice. Now came the silence before the storm. The emergency session of the Virginia State Judicial Review Board convened in a sterile conference room that bore no resemblance to the theatrical grandeur of Judge Thorne's courtroom. Here, beneath harsh fluorescent lighting and surrounded by law books that actually mattered, the reckoning would be swift and merciless. Attorney General Imani Hayes sat at the witness table, no longer the anonymous defendant who had endured 30 minutes of systematic humiliation. Her modest civilian clothes had been replaced by the crisp navy suit of her office, her credentials displayed prominently, her authority unmistakable. The transformation was complete and devastating. But the journey to this moment had been anything but simple. In the 72 hours following her courthouse revelation, Imani's office had become a war room. David Miller and his team worked around the clock, transforming years of suspicion into ironclad evidence. Phone calls poured in from across the state as word spread that someone had finally taken on the untouchable Judge Marcus Thorne. The media frenzy was immediate and overwhelming. Within hours of the courthouse confrontation, social media exploded with hashtags like #JusticeForOakhaven and Tiawa Attorney General Courage. The video footage captured by gallery members had gone viral, showing the moment when the most powerful judge in Virginia was humiliated by a woman he had dismissed as just another defendant. But behind the public attention, darker forces were mobilizing. Judge Thorne's allies in the political establishment began a whisper campaign designed to undermine Imani's credibility. They suggested she had orchestrated the entire incident as a publicity stunt, that her motives were political rather than judicial. The attacks were predictably vicious and predictably racist. Anonymous social media accounts questioned whether a black woman could be trusted with such significant authority. Talk radio hosts suggested she was part of a radical agenda to destroy traditional law and order. Death threats arrived at her office with disturbing regularity. Robert, her husband, had been her anchor throughout the storm. A history professor with a deep understanding of how institutions resist change, he provided both emotional support and strategic insight during the long nights when the pressure seemed overwhelming. They're attacking you because they're terrified, Isna, he told her during one particularly difficult evening when the hate mail had been especially vicious. You've exposed something they thought was safely hidden. They know that if you succeed here, their entire system of privilege and protection starts to crumble. The investigation itself had revealed layers of corruption that went far beyond anything Imani had imagined. Judge Thorne wasn't operating in isolation. He was part of a network that included law enforcement officials, court administrators, and even state legislators who had benefited from the systematic oppression of minority communities. David Miller's team had uncovered financial records showing that the corruption extended to bail bond companies, court reporters, and private attorneys who had all profited from the rigged system. The Oak Haven courthouse had become a criminal enterprise masquerading as a temple of justice. Now, as she sat in the sterile conference room facing the Virginia State Judicial Review Board, Imani understood that this hearing would determine not just Judge Thorne's fate, but the future of judicial reform across the entire state. Across the room, Judge Marcus Thorne looked like a man who had aged decades in the span of hours. His silver hair, once perfectly styled to project gravitas, now hung limp and disheveled. The judicial robes that had been his armor were gone, replaced by an expensive suit that suddenly seemed too large for his diminished frame. His attorney, Arthur Vance, was a legendary figure in Virginia legal circles, a man who had built his reputation defending the indefensible and making the guilty appear innocent. His presence at the hearing was itself a testament to how seriously Thorne's allies were taking this threat. But even Vance's considerable skills would be tested by the mountain of evidence Miller had assembled. "The board will come to order," announced Chief Justice Margaret Blackwell, her voice carrying the weight of absolute authority. "We are here to address allegations of systematic judicial misconduct, civil rights violations, and potential criminal behavior by Judge Marcus Thorne of Oak Haven County District Court." The formal language couldn't disguise the historic nature of what was happening. In 30 years of Virginia judicial history, no sitting judge had faced charges this serious, this public, or this thoroughly documented. David Miller approached the presentation table with boxes of evidence that represented months of meticulous investigation compressed into days of frantic activity. The scope of corruption they had uncovered went far beyond a single racist judge. It was a systematic conspiracy that reached into every corner of the Oak Haven judicial system. "Honorable board members," Miller began, his voice steady despite the magnitude of what he was about to reveal. "The evidence we present today documents not merely individual acts of bias, but a coordinated system of discrimination that has operated for over a decade." He activated a large monitor that displayed a statistical analysis so damning it made several board members visibly recoil. The data painted a picture of systematic racism that was both mathematically precise and morally horrifying. African American defendants in Judge Thorne's courtroom received sentences averaging 62% longer than white defendants for identical charges. Hispanic defendants faced fines that were consistently 47% higher. These disparities exist even when controlling for criminal history, legal representation, and all other relevant factors. But the numbers were just the beginning. Miller clicked to the next slide, revealing a timeline that showed how the bias had actually increased over time, becoming more systematic and more brazen as Judge Thorne grew confident in his immunity from oversight. "The pattern shows clear escalation," Miller continued. "In Judge Thorne's early years on the bench, racial disparities were significant but could potentially be explained by other factors. However, over the past decade, the bias has become so systematic and pronounced that it can only be explained by deliberate discrimination." He presented case studies that brought the statistics to life. A young African-American mother sentenced to 6 months in jail for unpaid parking tickets, while a white businessman with identical violations received community service. A Hispanic teenager given the maximum penalty for a minor drug offense, while a white college student with the same charge walked away with a warning. Each case was meticulously documented, with court transcripts, sentencing records, and witness testimony that painted a picture of systematic injustice that was breathtaking in its scope and shameless in its execution. But the racial bias was only part of the story, Miller said, clicking to reveal financial records that showed a web of corruption extending far beyond the courtroom. Judge Thorne received over $200,000 in payments from CCA Corrections, a private prison company based directly on the number of defendants he sentenced to incarceration. The longer the sentences, the higher his payments. A collective gasp went through the room. This wasn't just bias, it was the literal selling of human lives for profit. Judge Thorne had turned his courtroom into a marketplace where justice was auctioned to the highest bidder. Arthur Vance shifted uncomfortably in his seat, understanding that his client's situation had just moved from difficult to impossible. Financial corruption was one thing that even his considerable skills couldn't explain away as judicial discretion. But Miller wasn't finished. The next series of documents revealed the conspiracy that had protected this system for years. The Oak Haven Judicial Review Committee, responsible for investigating complaints against Judge Thorne, was composed entirely of his personal friends and political allies. Committee Chairman Robert Hastings played golf with Judge Thorne every Wednesday. Committee member Patricia Wells was Judge Thorne's former law partner. Committee member James Crawford had received over $50,000 in legal fees for work referred by Judge Thorne's office. The systematic nature of the protection racket was stunning. Over 50 formal complaints had been filed against Judge Thorne over the years, each one carefully buried by a review committee that had no intention of providing actual oversight. Miller presented email records showing the committee members coordinating their responses to complaints, often before they had even bothered to review the allegations. In one particularly damning exchange, Chairman Hastings wrote, "Another BS complaint about Marcus. Let's dispose of this quickly so we can get back to real work." The evidence kept mounting. Court Clerk Daphne Sterling had been altering official transcripts to hide the most egregious examples of bias, using correction fluid and careful retyping to make racist statements disappear from the official record. Prosecutor Wells Ashford had been coaching witnesses and hiding exculpatory evidence to maintain his conviction rate, even when he knew defendants were innocent. Most damning was the discovery of what investigators had dubbed the punishment protocol, a systematic approach to sentencing that Judge Thorne had developed over years of practice. African American defendants who showed any sign of defiance or self-advocacy received automatic sentence enhancements. Hispanic defendants were routinely subjected to immigration status checks, even when immigration issues had no bearing on their cases. White defendants, particularly those from affluent families, received systematic leniency that bore no relationship to the facts of their cases. The protocol had been documented in Judge Thorne's personal notes discovered during a search of his office. Written in his own handwriting were instructions like, "Uppity blacks need extra time to learn respect," and "Rich kids deserve second chances. They have futures to protect." Want to understand your constitutional rights like Attorney General Hayes? The Constitution Institute offers online courses taught by legal experts that break down complex law into understandable terms. Learn about civil rights, criminal procedure, and judicial oversight. Use promo code JUSTICE50 at constitutioninstitute.edu for 50% off your first course. Knowledge of the law is your best defense against those who would abuse it. But the most devastating evidence was yet to come. Miller had saved the audio recording from Imani's courtroom experience for last. Understanding its emotional impact would be overwhelming after the statistical foundation had been laid. Board members, what you are about to hear is a complete audio recording of Attorney General Hayes' experience in Judge Thorne's courtroom. This recording was made legally under Virginia Code Section 18.2-464, which permits parties to record legal proceedings for their protection. As Imani's calm voice played through the conference room speakers, documenting every threat, every violation, every moment of systematic abuse, the board members listened with expressions of growing horror. The contrast between her professional composure and Judge Thorne's increasingly unhinged behavior was stark and undeniable. "People like you think the rules don't apply." Judge Thorne's voice echoed through the room, each word dripping with racist venom. "You have a chip on your shoulder, a sense of entitlement." The racism was unmistakable, but it was the casual nature of it that proved most damaging. This wasn't an isolated incident triggered by unusual stress. It was the routine operation of a corrupt system that had been allowed to fester for years. When the recording reached the moment of revelation, when Imani's professional credentials had been revealed and Judge Thorne's world had collapsed in real time, several board members were visibly shaken. The transformation in Judge Thorne's voice from arrogant authority to desperate pleading was painful to hear. When the recording ended, the silence in the conference room was profound and uncomfortable. Chief Justice Blackwell looked at Judge Thorne with an expression of disgust that needed no verbal translation. But Miller had one final piece of evidence that would seal Judge Thorne's fate forever. He approached the evidence table and withdrew a thick folder that he handled with the reverence usually reserved for sacred documents. "Board members, during our investigation we discovered that Judge Thorne kept what he called his insurance files, detailed records of compromising information about other officials in the Oak Haven judicial system. These files document systematic corruption involving dozens of officials, including evidence of bribery, witness tampering, and conspiracy to obstruct justice." The revelation sent shockwaves through the room. Judge Thorne hadn't just been corrupt. He had been blackmailing other officials to maintain their silence about his activities. The insurance files contained photographs, recorded phone calls, and documentary evidence of corruption that reached into the highest levels of local government. Arthur Vance rose from his seat, his face pale with the understanding that his client's situation had moved beyond salvageable. "Your Honors, I request a brief recess to consult with my client." But Chief Justice Blackwell was having none of it. "Mr. Vance, your client will have ample opportunity to respond to these allegations. Please remain seated while Mr. Miller completes his presentation." Miller's final exhibits included witness testimony from Sarah Jenkins, the former court clerk whose meticulous personal diaries had provided a detailed record of Judge Thorne's systematic bias over 15 years. Her testimony, delivered via video link due to security concerns, was devastating in its quiet precision. "I kept detailed notes because I was afraid," she said, her voice barely above a whisper. "I knew what Judge Thorne was doing was wrong, but I also knew that anyone who challenged him would be destroyed. I documented everything because I hoped that someday, someone with enough power would finally hold him accountable." Her diaries revealed a pattern of corruption that went beyond systematic racism to include routine violations of due process, evidence tampering, and coordination with law enforcement to ensure predetermined outcomes. She had recorded instances where Judge Thorne had decided verdicts before hearing evidence, where he had coordinated with prosecutors to guarantee convictions, and where he had used his position to benefit political allies and punish enemies. Most disturbing were her accounts of what Judge Thorne had called his teaching moments, instances where he would deliberately humiliate defendants to send messages to their communities. These weren't isolated outbursts, but calculated psychological warfare designed to intimidate entire demographic groups. When Miller finally concluded his presentation, the silence that followed was pregnant with the weight of institutional failure. This wasn't just about one corrupt judge. It was about a system that had allowed such corruption to flourish for decades while turning a blind eye to the suffering it caused. Chief Justice Blackwell surveyed the evidence with the expression of someone who had just witnessed a crime scene. "Judge Thorne," she said, her voice cutting through the silence like a blade, "do you have any response to these allegations?" Arthur Vance rose unsteadily to his feet. The man who had built his reputation defending the indefensible now faced a case that even his considerable skills couldn't salvage. His usual confident demeanor had been replaced by the deflated posture of someone who understood that he was about to witness the destruction of a client's life and reputation. "Your Honors," he began, his voice lacking its usual commanding presence, "my client has served the people of Oak Haven for 30 years. While some of his methods may have been unorthodox, we must consider the context in which he operated." The weak opening drew sharp attention from the board members who recognized desperation when they heard it. Vance continued, clearly struggling to find solid ground in the mountain of evidence against his client. Judge Thorne inherited a court system that was already overwhelmed and under-resourced. He was forced to make difficult decisions under impossible circumstances. While some of his rulings may appear harsh in hindsight, they were made in good faith and within his judicial discretion. Chief Justice Blackwell interrupted with barely concealed contempt. "Mr. Vance, are you seriously suggesting that systematic racial discrimination, financial corruption, and conspiracy to obstruct justice can be explained as judicial discretion exercised under difficult circumstances?" Vance's pause was telling. Even he couldn't find a way to spin the evidence into anything resembling legitimate judicial conduct. "Your Honors, we maintain that any errors in judgment were isolated incidents that do not rise to the level of systematic misconduct." The response drew audible gasps from the gallery where representatives from civil rights organizations and community groups had gathered to witness the proceedings. The brazenness of claiming that 30 years of documented corruption were isolated incidents was breathtaking in its dishonesty. But Vance wasn't finished with his defense, though it was clear he was grasping at increasingly desperate arguments. "Furthermore, we contend that this entire proceeding is politically motivated, orchestrated by an attorney general seeking to advance her career through grandstanding and character assassination." The personal attack on Imani brought an immediate response from Chief Justice Blackwell. "Mr. Vance, you will confine your remarks to the evidence presented. Personal attacks on the attorney general will not be tolerated in these proceedings." But the damage was already done. By attacking Imani personally, Vance had revealed the poverty of his defense and the desperation of his client's position. When evidence is overwhelming, attacking the messenger becomes the only remaining strategy. Judge Thorne himself sat silent throughout his attorney's presentation. The man who had once commanded absolute authority in his courtroom now reduced to a spectator at his own destruction. The transformation was complete and devastating. The emperor's clothes had been stripped away, revealing nothing but prejudice and corruption beneath. If this story of justice served cold amazed you, wait until you hear about the corrupt police chief who arrested a federal judge's daughter. That story is even more unbelievable. Subscribe and ring that notification bell so you never miss these incredible true stories. The board's deliberation was swift and unanimous, but the formal proceedings continued with the methodical precision that major judicial decisions required. Each board member was given the opportunity to question both the evidence and the defense, though it quickly became clear that Judge Thorne's fate had been sealed the moment David Miller began his presentation. Board member Justice Raymond Clark, known for his conservative judicial philosophy, asked the questions that many observers had been thinking. Mr. Miller, this evidence suggests systematic corruption over many years. How was such behavior allowed to continue without detection by normal oversight mechanisms? Miller's response was devastating in its simplicity. Justice Clark, the oversight mechanisms were compromised from the beginning. The very people responsible for monitoring Judge Thorne's conduct were either his personal friends or direct beneficiaries of his corruption. The system was designed to protect him, not to ensure justice. Justice Maria Santos, the board's civil rights specialist, focused on the human cost of the corruption. Mr. Miller, do we have any estimate of how many lives were affected by Judge Thorne's systematic bias? Justice Santos, our preliminary analysis suggests that over 5,000 defendants may have received biased treatment over the past decade alone. The full scope of the damage may never be completely quantified, but we estimate that hundreds of people received unjust prison sentences. Thousands lost their livelihoods through excessive fines and license suspensions, and entire communities were terrorized by a judicial system that treated them as enemies rather than citizens. The numbers were staggering, representing a scale of systematic injustice that challenged fundamental assumptions about how American courts operated. This wasn't isolated misconduct, but institutional failure on a massive scale. When the questioning concluded, Chief Justice Blackwell called for final statements. Arthur Vance made one last desperate attempt to salvage something for his client, but his words rang hollow against the mountain of evidence that had been presented. Your Honors, Judge Thorne is a human being who made mistakes. He deserves compassion and the opportunity for redemption, not the destruction of everything he has worked for over 3 decades of public service. The plea for mercy was undercut by its complete failure to acknowledge the scope of the harm that Judge Thorne had inflicted. There was no acceptance of responsibility, no expression of remorse, no recognition of the lives that had been destroyed by his systematic corruption. Imani was given the opportunity to make a final statement, and her words carried the weight of both personal experience and institutional authority. Honorable board members, what we have documented here today is not merely judicial misconduct, but a betrayal of the fundamental promise that America makes to all its citizens. The promise of equal justice under law. Judge Thorne didn't just violate court rules or professional standards. He weaponized the judicial system against the most vulnerable members of our society, turning courts into instruments of oppression rather than temples of justice. Her voice carried the quiet authority that had commanded respect throughout her career, but also the moral passion of someone who had experienced systematic injustice firsthand. The evidence shows that Judge Thorne operated not as a judge, but as a predator, using his position to inflict maximum harm on people who had no power to fight back. He sold justice to the highest bidder, terrorized communities through systematic bias, and corrupted an entire institution to protect his criminal enterprise. She paused, allowing the weight of her words to settle over the silent courtroom. But perhaps most importantly, Judge Thorne represents a broader failure of institutional accountability. He was allowed to operate for 30 years because too many people in positions of authority chose comfort over courage, chose silence over justice. The question before this board is not just what to do with Judge Thorne, but what message to send about our commitment to the constitutional principles that define American democracy. When she concluded, the silence in the courtroom was absolute. The board retired for deliberations that lasted less than 30 minutes, a remarkably short time for proceedings of such magnitude, but a reflection of how overwhelming the evidence had been. When they returned, Chief Justice Blackwell's expression left no doubt about the outcome. Judge Marcus Thorne, she began, her voice carrying the weight of institutional authority and moral judgment. This board has reviewed the evidence of your conduct and finds it to represent the most serious violations of judicial ethics and federal law that we have encountered in our collective experience. She paused, surveying the courtroom before delivering the verdict that would reshape Virginia's judicial system. It is the unanimous decision of this board that you be immediately and permanently removed from the bench, stripped of all judicial authority, and barred from holding any position of public trust. Furthermore, we are referring the complete case file to the United States Department of Justice for federal prosecution on charges including conspiracy, civil rights violations, wire fraud, and racketeering. The words hit Judge Thorne like physical blows. His face crumpled as the reality of his complete destruction finally penetrated his consciousness. 30 years of accumulated power and authority had been swept away in a single afternoon, replaced by the prospect of spending his remaining years in federal prison. But the board wasn't finished. Chief Justice Blackwell continued with announcements that would reshape the entire Oak Haven judicial system. Additionally, this board is recommending immediate federal oversight of all court operations in Oak Haven County. The systematic nature of the corruption documented here requires comprehensive institutional reform under federal supervision. The decision represented one of the most sweeping judicial interventions in Virginia history, acknowledging that the corruption had been so pervasive that local remedies were insufficient. As court officers moved to escort Judge Thorne from the building, he made one final attempt to speak, but Chief Justice Blackwell cut him off with surgical precision. "Mr. Thorne, you forfeited the right to address this board when you chose to betray the oath of office you swore to uphold. Your time for speaking has ended. Your time for accountability has begun." The man who had once wielded absolute power in his domain was led away in handcuffs, his judicial robes replaced by the orange jumpsuit that would be his uniform for the foreseeable future. The reckoning was complete, but the work of reconstruction was just beginning. 6 months after the fall of Judge Marcus Thorne, the Oak Haven Courthouse still bore the scars of its systematic reconstruction, but the transformation was remarkable and continuing to accelerate. The building itself remained unchanged, the same brutalist concrete, the same intimidating architecture, but everything inside had been fundamentally altered. Judge Annabelle Rodriguez, the retired state Supreme Court justice appointed to oversee the transition, had approached her mandate with the methodical precision of a surgeon removing cancer. Her task wasn't simply to replace corrupt officials, but to rebuild an entire institutional culture that had been poisoned by decades of systematic abuse. The federal oversight team that arrived in the wake of the judicial review had been thorough and uncompromising. Led by U.S. Attorney Patricia Williams, a specialist in civil rights enforcement, they had conducted interviews with every court employee, reviewed every case file from the past 5 years, and implemented new procedures designed to prevent future corruption. The purge had been swift and thorough, but also careful to distinguish between those who had actively participated in corruption and those who had been victims or unwilling witnesses. Officer Miller, the bailiff who had laughed at Imani's humiliation, was among the first to be terminated and faced federal charges for civil rights violations. Court Clerk Sterling, whose altered transcripts had hidden years of abuse, was facing a potential 20-year federal sentence for conspiracy and obstruction of justice. Prosecutor Peterson, who had plea bargained his way out of prison time by providing testimony against his former colleagues, would never practice law again. His cooperation had been valuable, but his career was finished. He had taken a job selling insurance in a small town 300 miles from Oak Haven, his legal career destroyed by his complicity in systematic injustice. But not everyone had been complicit. Court reporter Janet Holloway, who had maintained accurate transcripts despite pressure to alter them, had been promoted to senior court administrator. Her integrity during the corrupt years had made her invaluable during the reconstruction process. Security guard Thomas Wright, who had treated all visitors with equal respect regardless of race, had been retained and given additional responsibilities training new staff in proper procedures. His example showed that even within corrupt institutions, individuals could choose to maintain their integrity. Most satisfying was the work of the Sentencing Review Board, a team of volunteer attorneys and law students who had taken on the monumental task of reviewing every case Judge Thorne had decided in his final decade on the bench. Working out of a converted storage room in the courthouse basement, they meticulously examined thousands of files, looking for patterns of bias in cases that warranted review. The process was painstaking and emotionally draining. Each case file represented a human life that had been affected by systematic injustice. The reviewers found themselves reading about families destroyed by excessive sentences, careers ruined by discriminatory fines, and communities terrorized by a judicial system that had treated them as enemies rather than citizens. The results were staggering and heartbreaking. Over 300 cases showed clear evidence of discriminatory sentencing that violated both state judicial guidelines and federal civil rights law. Dozens of defendants who had been railroaded into plea bargains were having their convictions overturned. The young man who had received 60 days for a broken taillight walked out of jail a free man, his record expunged and a formal apology from the state in his pocket. Maria Santos, the young mother whose license had been suspended for unpaid parking tickets, not only had her license restored but received a settlement from the state that allowed her to return to school and complete her nursing degree. The systematic injustice that had threatened to derail her life had been transformed into an opportunity for advancement. The financial reckoning was equally comprehensive and complex. The state had established a victim compensation fund financed by the seized assets of those involved in the corruption, but the scale of the damage made complete restitution impossible. How do you compensate someone for years of unjust imprisonment? How do you restore a reputation destroyed by systematic bias? The fund prioritized immediate needs, expunging criminal records, restoring professional licenses, providing counseling for victims of judicial trauma. But everyone involved understood that money could never fully address the psychological and social damage that had been inflicted. Sarah Jenkins, the former court clerk whose meticulous diaries had provided crucial evidence, found new purpose as a special consultant to Judge Rodriguez. Her 15 years of institutional knowledge, once used to enable corruption, now served as a roadmap for reform. The woman who had lived in fear of retaliation was now a key architect of the new system. "I stayed because I hoped someone would eventually hold him accountable," she explained during one of her training sessions for new court staff. "I documented everything because I believed that someday, someone with enough power would finally care about justice. I never imagined it would be the Attorney General herself who would walk into that courtroom." Her story had become legendary among civil rights advocates, an example of how ordinary people could contribute to extraordinary change by maintaining their integrity and documenting injustice even when it seemed hopeless. The private prison company that had been paying Judge Thorne faced massive federal lawsuits that had bankrupted them within 6 months of the initial revelations. CCA Corrections had lost contracts in 12 states as word spread about their role in corrupting judicial systems. Their executives faced federal racketeering charges that could result in decades in prison. Meanwhile, Marcus Thorne himself had become prisoner number 73,406 in the Federal Correctional Facility at Petersburg, Virginia. His appeals had been rejected at every level, his assets seized to pay restitution to his victims, his reputation destroyed beyond any possibility of rehabilitation. The man who had measured his worth by his power over others now counted the hours until his next meal, surrounded by the kind of men he had spent decades sending away with casual cruelty. The irony was not lost on anyone involved in his prosecution, but perhaps the most significant change was harder to quantify and more important than any individual punishment. The culture of fear that had permeated Oak Haven for decades was finally beginning to lift. Imani Hayes visited Oak Haven on a crisp autumn afternoon, not in any official capacity but simply to see the results of the revolution she had sparked. She parked in the same spot she had used 6 months earlier, walked the same path to the courthouse entrance, and observed the transformation with quiet satisfaction. The security checkpoint still existed, but the officers treated everyone with basic human dignity. When an elderly Hispanic man asked for directions in accented English, the guard responded with patience and courtesy, providing clear directions and even walking him partway to ensure he found the right courtroom. The lobby still buzzed with nervous energy. Courthouse visits were never pleasant experiences, but the conversations were different now. People spoke about fair treatment, about judges who listened, about a system that finally seemed to work for everyone rather than serving the interests of a privileged few. She found herself in the gallery of Courtroom 4B, now presided over by Judge Patricia Morrison, a young African-American woman whose reputation for fairness and legal acumen had already begun to restore community trust. Judge Morrison had been carefully selected not just for her qualifications but for her understanding of how systematic bias affected vulnerable communities. The morning docket proceeded with efficiency and respect, each defendant treated as an individual worthy of consideration rather than raw material for a conviction machine. When a young black defendant appeared on a traffic violation, Judge Morrison carefully reviewed the evidence, asked clarifying questions, and ensured that proper procedure was followed throughout the hearing. The contrast with Judge Thorne's approach was stark and encouraging. This was how justice was supposed to work: methodical, fair, and respectful of everyone's constitutional rights regardless of their race, class, or social status. A community organizer who had fought against Thorne's system for years approached her during a recess. James Washington had been one of the most persistent critics of the Oak Haven judicial system, filing complaint after complaint that had been systematically ignored by the corrupted oversight process. "You know," he said, his voice thick with emotion, "for the first time in my lifetime, people from this neighborhood are volunteering for jury duty. They're not afraid anymore. They actually want to participate in justice instead of avoiding it. The words carried a weight that no statistical analysis could capture. This was the true measure of success, not just the removal of corruption, but the restoration of faith in the system itself. When people believed that justice was possible, they were willing to participate in making it happen. As evening approached, Imani walked through the neighborhood that had borne the brunt of Thorne's systematic bias. The changes were subtle but unmistakable. Street corners that had once been sites of routine police harassment were now gathering places where young people felt safe to congregate. She saw Maria, the young mother from the courthouse hallway, picking up her son from soccer practice. The car she drove wasn't expensive, but it was legal and licensed. She had been able to keep her job, support her family, and rebuild her life after years of being trapped in the cycle of fines and suspensions that Judge Thorne had used to terrorize poor communities. "Mrs. Hayes," Maria called out, recognizing her despite the casual clothes. "I wanted to thank you. I don't know if you remember me, but I was in that courtroom the day everything changed." The conversation that followed was brief but powerful. Maria's gratitude was touching. But what struck Imani most was her confidence. The fearful, desperate woman from the courthouse had been replaced by someone who believed in her own worth and her right to be treated with dignity. At a community center a few blocks from the courthouse, Imani encountered a scene that would have been impossible under the old regime. A group of teenagers, mostly minority kids, who would have been viewed as potential criminals by Judge Thorne, were participating in a mock trial program designed to teach them about their constitutional rights. The instructor was Rebecca Miller, David's younger sister and a recent law school graduate who had been hired as part of the reform effort. Her lesson that evening focused on the Fourth Amendment protections against unreasonable search and seizure. "Remember," she told the kids, "knowing your rights is your best protection. No one, not a police officer, not a judge, not anyone in authority, can take away your constitutional protections just because they don't like the way you look or where you come from." The message was powerful, but what struck Imani most was the way the kids responded. They asked intelligent questions, challenged assumptions, demanded explanations. They were learning not just to submit to authority, but to understand and claim their place as equal citizens in a democratic society. 15-year-old Marcus Williams raised his hand. "Ms. Miller, what if a police officer lies about what happened? How do we prove what really occurred?" The question showed sophisticated understanding of the challenges facing minority communities in their interactions with law enforcement. Rebecca's answer was both practical and empowering. "That's exactly why body cameras and witness statements are so important, Marcus. And that's why we document everything. The more evidence we have, the harder it becomes for bad actors to get away with misconduct." The conversation continued for another hour, covering topics from traffic stops to court appearances to the appeals process. These kids were getting an education in constitutional rights that would serve them throughout their lives, an investment in their future that would pay dividends for generations. This was the revolution Imani had started. Not just the removal of corrupt officials, but the empowerment of people who had been systematically denied their rights. Knowledge was power, and power shared was power multiplied. But even as she celebrated these victories, Imani understood that the work was far from complete. The Oak Haven Courthouse was just one building in a vast judicial system. Similar problems existed in courthouses across the state, across the nation. Systematic bias, institutional corruption, and the abuse of power were not isolated phenomena but part of a larger struggle for true equality under law. As she prepared to leave Oak Haven, her phone buzzed with a text message from an encrypted number. "The patterns you found in Oak Haven exist in at least 12 other jurisdictions. We have documentation. Are you ready for the next phase?" She stared at the message for a long moment, understanding its implications. What she had uncovered in Oak Haven was not an aberration, but a symptom of a much larger disease. The fight for justice was not ending. It was expanding. The message continued. Federal investigations show similar corruption patterns in Riverside County, Maryland, Jefferson Parish, Louisiana, and Maricopa County, Arizona. Private prison companies have been using the same model nationwide. We need someone with the authority and courage to coordinate a multi-state response. As she walked back to her car, Imani passed a small memorial that had been erected near the courthouse entrance. It wasn't elaborate. Just a simple plaque embedded in the sidewalk with words that captured the essence of what had been accomplished. "In memory of all who suffered injustice in this place. May their voices never be silenced again." But it was the smaller text below that carried the real message. Justice delayed is not justice denied when those with power finally choose to act. The memorial had been funded by donations from across the community, with contributions ranging from a $5 bill donated by an elderly woman who had been humiliated in Judge Thorne's courtroom to a $50,000 contribution from a legal foundation dedicated to civil rights advocacy. The autumn evening was growing dark, but lights were coming on throughout the neighborhood. In windows and doorways, families gathered for dinner, children did homework, parents planned for futures that suddenly seemed more secure. The community was healing, slowly but unmistakably. Imani's car started with a quiet hum, and she pulled away from the courthouse for what might be the last time. In her rearview mirror, she watched the building recede into the distance, no longer a symbol of oppression but a testament to the possibility of change. The radio crackled to life as she reached the highway, bringing news that made her heart race with both excitement and apprehension. A federal judge in Alabama had just been arrested on corruption charges remarkably similar to those that had brought down Judge Thorne. The investigation had been triggered by a whistleblower who cited the Oakhaven case as inspiration for coming forward. The pattern was emerging more clearly now. What had happened in Oakhaven was not an isolated incident, but part of a coordinated network of judicial corruption that reached across state lines and into the federal court system itself. Her secure phone rang as she merged onto the interstate. The caller ID showed only a number, but she recognized the voice immediately. FBI Director Sarah Mitchell, one of the few federal officials she trusted completely. "Imani, we need to talk. What you uncovered in Oakhaven has opened a door that we can't close. The corruption goes deeper than anyone imagined, and we need your help to coordinate the response." The conversation that followed lasted 2 hours as Imani drove through the darkness, learning about a conspiracy that made Oakhaven look like a minor administrative error. Private prison companies had been systematically corrupting judicial systems across 12 states, using a model perfected in places like Oakhaven to generate profits from human suffering. We're talking about a potential RICO case involving dozens of judges, hundreds of court officials, and several major corporations, Director Mitchell explained. The financial trail shows over $200 million in bribes and kickbacks over the past decade alone. The scope was staggering, representing the largest judicial corruption investigation in American history. But it was also an opportunity to address systematic injustice on a scale that could transform the entire American legal system. "What do you need from me?" Imani asked, though she already knew the answer. "We need you to lead a joint federal-state task force with the authority to investigate and prosecute corruption wherever we find it. The president is prepared to give you whatever resources you need, but this is going to be a multi-year commitment with significant personal and professional risks." Imani thought about the encrypted message on her phone, about the choice that lay ahead. She could return to her normal duties as Attorney General, content with the knowledge that she had made a difference in one small corner of the world, or she could accept that what she had found in Oakhaven was just the beginning of a much larger story. The highway stretched ahead in the darkness, lit by occasional streetlights that pushed back the shadows for brief moments before surrendering to the night. Behind her, Oakhaven slept peacefully for the first time in decades. Ahead lay challenges that would test everything she had learned about justice, power, and the courage required to use authority for the protection of the vulnerable rather than the advancement of the privileged. "Sarah, send me everything you have. If this conspiracy is as extensive as you suggest, then we have an obligation to expose it completely. The people who suffered under these corrupt systems deserve nothing less than total accountability." As she drove through the night, Imani Hayes understood that her work as a reformer was just beginning. The system that had protected Judge Marcus Thorne for 30 years was vast, entrenched, and defended by people who had much to lose from exposure. But it was also brittle, dependent on secrecy and the silence of victims who had finally found their voice. The miles stretched endlessly ahead, each one carrying her further from the courthouse where she had endured systematic humiliation and closer to a destiny she was only now beginning to understand. The dashboard clock read 11:47 p.m., but sleep was impossible. Her mind raced with the implications of what she had learned during the encrypted phone call that had lasted nearly 2 hours. The conspiracy was more sophisticated than anyone had imagined. Private prison corporations hadn't simply been bribing individual judges. They had created an entire shadow system of justice designed to maximize incarceration rates and minimize due process protections. The model perfected in Oakhaven had been replicated in dozens of jurisdictions across the country, creating what federal investigators were calling the largest systematic corruption of American courts in history. But it was the personal stories that haunted her most. During the call, she had learned about 12-year-old Marcus Williams in Alabama, sentenced to adult prison for a minor theft because Judge Harrison Mitchell needed to meet his quota for juvenile transfers. She heard about Maria Gonzalez in Texas, whose children were placed in foster care after she received a 6-month sentence for unpaid traffic fines that a white defendant would have resolved with community service. Each case represented not just statistical data but a human life destroyed by systematic injustice. The weight of their suffering pressed against her consciousness like a physical force, demanding action that went beyond mere prosecution to fundamental transformation of American judicial culture. The lock had clicked twice, and the silence that followed was pregnant with possibility. In courthouses across Virginia, across America, other Marcus Thornes sat behind their benches, confident in their power and certain of their immunity. Her phone buzzed with another message, this one from Robert. Saw the news about Alabama. I know what you're thinking. I also know you're going to do what's right, regardless of the personal cost. I'm proud of you. Drive safely. The simple text message carried years of shared understanding and unconditional support. Robert knew that his wife was about to embark on a mission that would consume years of their lives and expose their family to unprecedented scrutiny and potential danger. His response was characteristically understated but deeply meaningful. They were about to learn how wrong they were. The revolution in Oak Haven had been just the first battle in a war for the soul of American justice. And Imani Hayes, the woman who had endured 30 minutes of systematic humiliation to expose decades of corruption, was ready to fight that war for as long as it took. As she crossed into Maryland, Imani's mind turned to the practical challenges ahead. Leading a multi-state corruption investigation would require unprecedented coordination between federal and state authorities. She would need to build a team capable of simultaneously pursuing dozens of complex cases while maintaining the security necessary to prevent evidence destruction and witness intimidation. The personal risks were equally daunting. Judge Thorne had been a small-time operator compared to some of the figures now in the crosshairs of federal investigation. Circuit Judge Rebecca Harrison in Louisiana had connections to organized crime families dating back 3 generations. District Judge Michael Castellano in Arizona had used his position to launder money for Mexican cartels, while systematically targeting immigrant communities for harsh sentences. These weren't just corrupt officials. They were dangerous criminals with vast resources and no scruples about eliminating threats to their operations. The FBI had already briefed her on credible death threats against federal investigators, and security protocols for her family would need to be implemented immediately. Justice, true justice, was not a destination but a journey. And the journey was far from over. But alongside the dangers came unprecedented opportunities for systemic change. The scope of the corruption had shocked even veteran federal prosecutors, creating political momentum for reforms that would have been impossible under normal circumstances. Congressional leaders from both parties were already calling for emergency hearings on judicial oversight, and the president had privately committed to supporting whatever resources the investigation required. In the distance, her phone rang again with a call from the encrypted number. She glanced at the display, then back at the dark highway stretching endlessly ahead. The choice was simple, really. She had seen what happened when good people remained silent. She had witnessed the price paid by those without power when those with authority chose comfort over courage. The caller was FBI Deputy Director James Patterson, his voice tight with urgency. Imani, we've got a problem. Judge Harrison in Louisiana got word about our investigation somehow. She's scheduled an emergency hearing for tomorrow morning. We think she's planning to destroy evidence and eliminate witnesses. The news sent adrenaline coursing through Imani's system. This was exactly what they had feared. A systematic effort to obstruct justice before the investigation could gather momentum. What's our timeline for intervention? We have federal marshals positioned outside the courthouse, but we need judicial authority to prevent the hearing from proceeding. Can you get an emergency injunction from federal district court? The request was complex and unprecedented. Federal courts rarely interfered with state judicial proceedings, but the circumstances were extraordinary. If Judge Harrison succeeded in destroying evidence, dozens of victims might never see justice, and the conspiracy could escape accountability entirely. I'll handle it, Imani replied, her mind already working through the legal procedures required. But we need to be prepared for this to go public immediately. Once we file federal papers against a sitting state judge, the media frenzy will be unlike anything we've experienced. She answered the call. This is Attorney General Hayes. Tell me everything. The conversation that followed lasted another hour, as federal investigators outlined emergency procedures for evidence preservation and witness protection. The scale of the operation was breathtaking. Simultaneous enforcement actions across 12 states involving over 300 federal agents and requiring coordination with dozens of local law enforcement agencies. The voice on the other end began to speak, outlining a conspiracy that reached into the highest levels of state and federal government. A network of corruption that made Oak Haven look like a minor administrative error. As the details unfolded, Imani understood that what she had thought was an ending was actually a beginning. During a brief pause in the conversation, Imani found herself thinking about the memorial plaque outside the Oak Haven courthouse. Justice delayed is not justice denied when those with power finally choose to act. The words had seemed inspirational when she first read them, but now they carried the weight of personal responsibility that was almost overwhelming. Every hour of delay meant more victims suffering under corrupt systems. Every procedural challenge overcome brought justice closer to communities that had been systematically oppressed for generations. The mathematics of human suffering demanded action regardless of personal cost or political consequences. The war for justice was expanding, and she was ready to lead it. By the time she reached the outskirts of Washington, D.C., the operational plans were taking shape. Emergency task forces would be deployed to each target jurisdiction, with federal prosecutors working alongside hand-picked state officials who had been thoroughly vetted for integrity. The private prison corporations would face simultaneous RICO prosecutions designed to dismantle their operations permanently. Most importantly, victim advocacy centers would be established in each affected community, staffed by attorneys and counselors trained to help people navigate the complex process of having their cases reviewed and their rights restored. The investigation wasn't just about punishing corruption. It was about healing the communities that had been damaged by systematic injustice. In the courthouse in Oak Haven, the lights went out one by one as the cleaning crew finished their work. The building settled into the quiet rhythms of night, no longer haunted by the ghosts of systematic oppression. In a few hours, it would wake to another day of proceedings conducted with fairness, dignity, and respect for the constitutional rights of all citizens. The symbolism was powerful but incomplete. Oak Haven represented what was possible when corruption was exposed and accountability enforced. But until similar transformations occurred across the country, the victory remained isolated and vulnerable to regression. But across the state, in other courthouses that still bore the cancer of corruption, the real work was just beginning. The phone call continued as Imani drove through the darkness, her voice steady and determined as she accepted the next phase of a mission that would define the rest of her career. As she navigated the increasingly complex traffic patterns approaching the Capitol, Imani reflected on the journey that had brought her to this moment. 6 months ago, she had been a respected but relatively unknown state attorney general. A simple traffic citation had transformed her into the face of a national movement for judicial reform. The irony was not lost on her. Judge Thorne's systematic bias had been designed to silence and intimidate people exactly like her. Instead, his corruption had created the catalyst for the largest judicial reform movement in American history. His attempt to demonstrate absolute power had revealed its fundamental weakness: dependence on the silence of victims who finally refused to remain quiet. The Attorney General was going to war, and this time, she wouldn't be fighting alone. The support network that had emerged around the investigation was unprecedented in its scope and diversity. Civil rights organizations, legal reform advocates, community activists, and even conservative judicial groups had united behind the common goal of restoring integrity to American courts. Former prosecutors who had witnessed corruption but lacked the authority to address it were volunteering their expertise. Retired judges whose reputations had been tainted by association with corrupt colleagues were offering testimony. Victims who had suffered in silence for years were finding the courage to speak publicly about their experiences. The movement had transcended traditional political boundaries, creating a coalition focused solely on the principle that justice should be blind to everything except the law and the facts. This wasn't about liberal versus conservative judicial philosophy. It was about basic honesty and integrity in the administration of justice. The story of Marcus Thorne had ended in a federal prison cell. The story of Imani Hayes was just beginning to write itself across the landscape of American justice, one corrupt courthouse at a time. As dawn approached, Imani's phone buzzed with updates from across the country. Federal agents were in position outside courthouses in 12 states. Emergency judicial orders had been signed to prevent evidence destruction. Witness protection protocols were activated for dozens of potential victims and whistleblowers. The most significant development came from an unexpected source: Judge Harrison herself. Faced with imminent federal intervention, she had attempted to negotiate a plea bargain in exchange for testimony against higher-ranking officials in the corruption network. Her offer had been rejected, but it confirmed what investigators had suspected. The conspiracy reached much higher than individual trial judges. And somewhere in the distance, in courthouses not yet touched by reform, other judges were about to learn that their day of reckoning was approaching. The woman who had stood silent for 30 minutes while enduring systematic humiliation had found her voice. The final preparations were being made for what media outlets were already calling the most significant judicial enforcement action in American history. Over 200 search warrants would be executed simultaneously at dawn, targeting judges, court officials, private prison executives, and the political figures who had protected them. Now the whole system would hear it. The final text message arrived as she reached the Virginia state line, heading toward Washington, D.C., and a meeting that would launch the largest judicial corruption investigation in American history. Operation Clean Sweep begins at dawn, simultaneous raids in 12 states. The revolution you started in Oak Haven is about to go national. Thank you for having the courage to stand up when it mattered most. The message was signed with initials she recognized. FBI Director Sarah Mitchell, whose own career had been defined by fighting corruption at the highest levels of government. The partnership between federal and state authorities that had seemed impossible just months earlier was now a reality, unified by the common goal of restoring integrity to American justice. Imani smiled in the darkness, understanding finally that her humiliation in Judge Thorne's courtroom had been the first domino in a chain reaction that would reshape American justice. The 30 minutes of systematic abuse she had endured would ultimately protect millions of Americans from similar treatment. As she pulled into the parking garage beneath the federal building where the final operational briefing would take place, Imani felt the weight of history settling around her. In a few hours, the sun would rise on a new chapter in American jurisprudence, one where systematic corruption would no longer be tolerated, where victims would have voices, and where the promise of equal justice under law would finally be more than just words carved into courthouse walls. The lock had clicked twice. The silence that followed would echo through his history.